All right.
Okay.
Like we've got the recording going, it's 1:01, so I'm just gonna get started. So thanks everybody for joining us today for this presentation on Section 8 voucher discrimination in Vermont. This panel is brought to you by the Vermont Human Rights Commission and Vermont Legal Aid, and it's part of the Fair Housing Month activities that we're doing in collaboration with lots of different partners across the state, and namely, I think CVOEO, Department of Justice, VHRC, Legal Aid, and Department of Libraries, and many, many other sponsors that I will miss. CVOEO has a good full long list of those if you're interested. And you can check out the Fair Housing Month calendar of activities on CVOEO's website, which I don't have here, but maybe Corinne can put in the chat for us. So today we're going to spend our time talking a little bit about the history of Section 8 vouchers, the law regarding discrimination around Section 8 vouchers, and then some things that you can do if you think that you might be discriminated against. So Melissa Horwitz from the Human Rights Commission, she's an investigator and an attorney. She's going to be talking to us about a lot of the legal and history aspects. I'll be talking about investigation and evidence gathering, and Cassie Burdyshaw will be facilitating and helping move along the conversation. Before we get started, we're going to have Sean Thomas, who is the field director for the Vermont State Office of HUD. I think I got that title correct, but he can correct me if I'm wrong. He's just going to give us a quick little warm-up welcome before we get into it. So Sean, go ahead.
Thank you, Devon. Yeah, I'm Sean Thomas. I'm actually the state director for HUD here in Vermont, and I welcome you all here today. Greetings from Secretary Fudge and the whole HUD family. Ending housing and discrimination is going to be a top priority of the Biden administration. Many Vermonters rely upon the Section 8 program to make better lives for themselves and for their families, and barriers that get in that way need to come down. This workshop that you're attending today serves a very important educational role for our state, because the more we educate, the more we reach, the more we help. This is a fairly good state when it comes to housing discrimination, but we can and must do better. And your HUD team here in the state is here to help you. Besides myself, I have Katie McKelvick, who's a new staffer as a program analyst. It's the first time we've had a full functioning HUD office in quite some time. And I just want to end by thanking Vermont Legal Aid, the Human Rights Commission, and CVOEO, and the many other partners who are putting this on today. And I encourage you to work with HUD to end discrimination in our state and in every state of the union. Thank you.
Great. Thank you so much, John. I'm so glad that you could join us. Just a reminder as well, if you have questions, you can go ahead and put them in the chat, and Cassie will be reading the chat, and we hope this can be somewhat informal. So if it's a good time to break in, Cassie will break in and let us know of questions, if they can be answered, if they're relevant to what we're talking about right now. She'll let us know, and if not, we can also have time for questions at the end.
And that chat is at the bottom. If you hover your mouse over the bottom, a bar should pop up, and in the middle is the word chat and a speech bubble. So click on that and you can type in your question, and I will take a look at it and pass it on.
Thanks, Cassie. So I wanted to start a little bit, and I'll try and keep this brief, but history is something I'm very interested in. So I thought I would do a brief history of, voucher discrimination and how we ended up with the Section 8 Housing Choice Voucher. So basically, I think a lot of people are probably aware that originally, we've had public housing, back since probably the 30s. But it became like in the 70s and 80s that we had a lot of high-rise towers, and there was public housing was very condensed And there was a lot of poverty associated with that type of public housing. And so HUD, became aware of this and thought that this was not maybe the best form of public housing. So in the 90s, they started a program that became known as the Housing Choice Voucher program, and better known as Section 8, that would give people a choice. They would give them a certain amount of money and they could go and seek out their own housing with that amount of money. And the goal was that they would be able to not live in concentrated poverty, have more access to different neighborhoods with, different schools, different employment, and hopefully different health outcomes, all of these things. So they, started knocking down the towers and began giving out these vouchers where people could go use these with private landlords. So that the program changed significantly, and people ended up with these vouchers that they could go out and use. As I'm sure many of you are aware, it's really hard to get vouchers. There are a lot of people want them. They are really helpful. Another issue is that they can be difficult to use. There's a lot of vouchers that go unused. And some of the reasons for that is there's a short timeline. You have 60 days to find a place. In places like Vermont, we know there's a lack of affordable housing. And so that can be a limitation. We know there's discrimination still when it comes to vouchers. And so that can make it difficult for people to use their vouchers within that time period. And there's also, there's steps that landlords and tenants have to go through to verify, the ownership of the property and the safety inspections that have to happen before someone can move in. So those are all things that are just challenges to using vouchers. But, what we're going to focus on today is the discrimination part of it and how that makes it difficult to use the vouchers. So let's just start off generally, what is fair housing? Make sure we're all on the same page. So fair housing is the right to equal opportunity and housing choice, and the right to rent or buy a dwelling free from discrimination. Like I just touched on earlier, we know, where you live is really important to your life. It can be whether you can find stable employment close to you, or whether you have to, find transportation and ways to get to work. Whether, there's good schools, there's good parks, whether there's a grocery store close by or not, and just overall health and well-being. So it's very important to all of us where we live, and we should all be able to have access to the housing that we want to live in. So if we're talking about discrimination, we first have to look at who is protected from discrimination. So what are the protected classes? And this differs between the federally protected classes, which federal law gives us, and our state protected classes, which Vermont has in addition to the federally protected classes. So at the federal level, we see disability, race, sex, color, national origin, religion, and family status. And that's whether you have children or don't have children. Whereas in Vermont, we also have public assistance, which is where the housing voucher would come in, gender identity and sexual orientation, age, marital status. So this is if you're single or married, you can't be discriminated against based on that. And victims of domestic violence are also protected. This is a more recent law that was passed by the legislature within the last couple of years. So what is housing discrimination? And this is general for all those protected statuses, but we will try and focus specifically, just because we only have so much time, on the on housing vouchers. So things that can't be done. You can't say housing's taken when it's not. So if an individual shows up, or a family, and says, we have a housing voucher and we've seen your ad that you have an available apartment and we'd like to rent it, and then all of a sudden that property is not available after you say you have a housing voucher. That's illegal, especially when you see that the ad is still running and after you've said that you can't do that. If you come to talk to someone about renting a property and they try and steer you away from that property, say, oh, I have a property in this other town that I think you'd be much more comfortable in, or, you know, the people in this neighborhood would probably not be that nice to you or not be that comfortable with you because you have a housing voucher. That's illegal. They can't steer you into another neighborhood. Clearly just flat out refusal saying, I don't rent, or I'm not going to sell this, or well, rent in this situation to someone with a housing voucher. Just straight out saying that is illegal. Different rules or conditions. You can't charge. So if you say you have a housing voucher and then they say, okay, we'll rent to you, but we're going to charge you a higher rent or security deposit because you're paying with a voucher or a subsidy. That is not okay. That is legal. Discriminatory ads. So if you see an ad in the paper that says we don't rent to someone with a voucher or we don't accept Section 8, that's illegal and something that should can be reported to us or to HUD, or you can make a call to legal aid. You know, threats or intimidation or harassment can be very serious here. Even like if you are renting, this can come up a lot too, because landlords know that if you get evicted, that can threaten your voucher and they can try and use that, hold that against you. So they can use threats and intimidation that if you don't do this, this can also happen with, you know, kind of a double discrimination with like sexual harassment, that if you don't give in to this, you know, I'm going to evict you and then you could potentially lose your voucher. And it's really serious. So obviously that's illegal. Just like anyone else, they cannot, landlords cannot refuse to provide you a reasonable accommodation because you have a voucher. And that's, again, something that they could use as a threat or to harass you. Landlords also can't say that they'll only rent a certain apartment to you if there's an apartment complex. You know, they can't just have set aside, you know, just like with people with disabilities, unless there's a special reason for it, or any other person of a protected status. You can't just say, well, I have this one special apartment that I'll rent to you. And other things to watch out for, you know, landlords can't just have minimum income requirements that would disqualify someone on a voucher. So if they tried to make that your minimum income requirement is like 150,000, just to preclude people with vouchers because they wouldn't be able to get a voucher if they made that much. So that would also be, you know, most likely applying different terms and conditions to people because most likely other people wouldn't fit that either. So, you know, they can't just make that so you can't qualify. And another thing to watch out for in this area is that there can be double discrimination that happens a lot. So landlords can use your voucher to discriminate against you on a different basis than the voucher. So these inspections sometimes that have to be done can be a cover up, because, you know, if if the inspection is taking place and there's something that is not up to safety standards, and they will say, well, I'm not going to fix it. And that also could be a cover up, like, I don't want to rent to this person with children, so I'm just not going to fix this. And it could really be about the discriminating against people with children or someone of a different race or religion. You know, sometimes those can be hard to prove, but it's something to look out for as well.
Can you actually go to the next slide? I accidentally flipped them. Yeah, that one. Thank you. So I realized at the beginning of this, I forgot to introduce myself. So I guess I'm gonna do that now. My name is Devon Ayers. I work at Vermont Legal Aid in the Housing Discrimination Law Project. My primary job there is investigating and gathering evidence for housing discrimination complaints. I also do support cases that our attorneys bring against landlords. So I'm just going to talk a little bit about what should you do if you suspect someone is discriminating against you? What are the steps that you need to take? So first of all, it can be really, really tricky to know if this is happening to you. So we always want to advise people as you're going through the housing search process, with every search that you're doing, document what you're doing, particularly if you're in a group that is discriminated against frequently. So if you're a voucher holder, you're discriminated against frequently. If you have a disability, if you have minor children, if you are a person of color, in all of these categories, I would recommend that you're documenting your housing search. So what does that mean? That means that when you're communicating with landlords, if possible, you're communicating with them through email and text message, right? It's great to have a written record of your interactions with landlords from start to finish, if that's possible. It's not always possible. Sometimes landlords want to talk on the phone. Sometimes you do go in person to places, and we'll talk about that in a second. When you are finding a place that you would like to see, that you're serious about, that you think you might want to rent, make sure you save the advertisement. You can just have like a little folder. If it's like Craigslist, save it so that way you have the property, where it's located, and the best way to contact the landlord. That could be really important later on in the process. When you're having conversations with landlords, it's okay to record those conversations if you're over the phone or in person. A lot of people do this just by using their voice memo app on their phone. You don't have to have any special technology, and you don't have to tell the landlord that you're recording. In fact, if you do tell the landlord that you're recording, they'll probably maybe not want to talk to you, or it might change the way that they interact with you. So, you know, if we want to get an accurate picture of what the landlord's practices are, it's okay to do that. Vermont is a single party recording state. You don't need to have permission. If the interaction is in person and unrecorded, we always recommend that as soon as it's over, you go back and you write down whatever happened as soon as you can. Include information like the property address, the time of day, the date, the name and contact information of anybody else who was there, and what happened. You know, it's a good practice to do this, even if you're not sure of what's going on. You might not have a clear picture that discrimination is happening to you, but the more that you get into the habit of just documenting every step of the process, if you get to the end of that and you feel like, you know what, something was not right about this landlord, or that seemed really suspicious to me, then you have a written record that we can then use later to use as evidence. We can compare it to other people's interactions. And it just is better in terms of like people's memories are faulty, people don't always remember the date, or we have experiences pretty frequently where they don't remember the property address or the landlord's name. And so the more that you just are in the practice of writing these things down, the easier it's going to be if we need to bring a case later. So that's part of my job. So one thing that we do when we're discriminating, not when we're discriminating, I'm sorry, I'm not discriminating. When we're investigating whether or not a landlord is discriminating, is that we consider something called testing. So Legal Aid runs a whole program that is dedicated to investigating housing discrimination. what that looks like is we basically recreate the housing interaction, or we simulate a housing transaction. So for example, sorry, I'm just trying to find the right screen. For example, if there's an African-American who's being discriminated against, we might send out another African-American and a white tester. We'll send them with the same information, right? About who the landlord is, what the property is like. We'll give them really similar characteristics. So similar education, similar income, similar jobs, similar age, similar familial makeup, similar marital status. We try to make everything as similar as we can, except the thing that we think is happening with discrimination. And so we have people go out and try to rent these apartments and document what's happening to them, just like I suggested to you, from start to finish. And then we're able to compare what happened to the black tester and what happened to the white tester. So when we've done that, we've gathered credible, objective evidence that shows how the testers, black tester and white tester, are being treated. So that evidence is admissible in court, it's admissible in HRC proceedings, and it's really useful in terms of like helping us discover what is really happening with the landlord. And this is actually something that you can do yourself. So if you think you're being discriminated against, you can actually just have a friend call and say, hey, I'm really interested in this apartment, and see where it takes them. You don't need to have legal aid involved. You can do this yourself, document it yourself, and it's just as good as when I do it. And the more that you do things like that, the better you'll get at it, at like gathering the evidence. So when you do that, you want to make sure that the person is available to see the apartment, and you just take it as far as you can. Don't have people fill out fraudulent applications though. Just would like to point that out. Like don't fill out an application if you're not serious about renting it, and don't put false information on an application, even if you're pretending to be something else when you're looking for the apartment in the aid of your friend. So when you might need help with this is when there's something more going on than just voucher discrimination. So many people who have vouchers are also part of other federally protected classes, as Melissa said before. So many people have vouchers and a disability. Many people have a voucher and children, or voucher and are a person of color. So if you're in this category where you have a voucher and you're also in another class of people that gets discriminated against frequently, your investigation gets a lot more complicated at that point, and it's a lot more difficult to uncover what is going on. So at that stage in the process, we would recommend that you call legal aid right away to say, I really need help investigating this. The sooner you call, the better, because as you know, this housing market is absolutely bonkers, and things, as soon as they appear, they disappear, especially right now. So if you want us to be able to really take a crack at investigating it, as soon as you're suspicious that something is going on, you should call. And when you call, you need to have some information available. You need to know, where is the property? Who is the landlord? Sometimes you don't know who the landlord is, but we need to know, where was the advertisement? Did you see it on Craigslist? Was it a sign that you saw out on the road? Was it word of mouth? We need to know how you heard about the apartment. And so if it's a sign on the road, take a picture of it. If it's a advertisement on Craigslist, download it or screenshot it and send it to us. If it's word of mouth, you need to give us like the landlord's phone number and how you knew how you were going to get in touch with them, right? All of this information is essential to carrying out a very fast and expedient investigation. Sometimes investigations can take a week, Sometimes, particularly more complicated ones, can take several weeks to several months. There are often times when we start to investigate a property, and in the first round of testing, where the first few people we send out, we think, you know, this is kind of suspicious, but we don't really have good evidence here. And then you do the same test multiple times over a long period of time, and then you can begin to see patterns emerge. And so sometimes it's not an instantaneous answer to, am I being discriminated against? We know landlords can be very subtle, that it's not always just saying, I'm not going to rent to you. We know that sometimes it's that they respond to you in a different amount of time, or they don't respond to you at all, or they respond to your friend very quickly and it took them 2 weeks to get to you, or that you get there and suddenly the apartment is gone. Is it really gone? Or, you know, do they not want to rent to you because they found out you had a voucher? So there can be a lot of different things going on, and discrimination is not always in your face, obvious. So that's why we do these kinds of investigations. And that's why we encourage you to do those investigations yourself. You know, always carry a notebook, always take pictures, record when you can, and make sure you keep track of whatever evidence you're gathering in your housing search. The last thing I will say that I didn't mention before is that I think anytime you can take another person with you to view an apartment, or even have somebody else in the room with you, if you're on speakerphone with a landlord, if you're not recording, that's also good, because you have a witness, and having a witness to whatever exchange is happening is going to be more credible evidence, right? That when it's a he said, she said sort of thing, or like, you know, two different testimonies, that two people saying completely different things, it can be really difficult to say, like, what's really going on here? How do we know it's really discrimination? If you have a witness, that can certainly help you a lot. I'm trying to think if I missed anything. I don't have my notes up.
And this might be a good moment for a question from the audience.
Great.
So somebody is wondering, are there trainings for landlords for how to conduct business without engaging in discrimination?
There are, and in fact, there is one coming up that the Apartment Association, the Apartment Owners Association, and also the attorney from Legal Aid, Rachel Batterson, is going to be conducting together later this month. I think I see Corrine over there looking for the date. She'll pop that into the chat for you, but that's a great question. We love it when landlords want to know best practices and how to avoid this.
Great. And I think, Melissa, do you also have information and can tell us more about what someone who believes they've been discriminated against can do?
Sure. Yeah. Following Devon's great information, once you have that information, or if you believe you've been discriminated against, you have two choices on where you can go. So you can go to the Human Rights Commission. Well, actually, probably three. You can also call HUD and file a complaint there. Oftentimes, they will refer it to the Human Rights Commission, although not always. Or you do have the option of filing lawsuits. I will speak to our process, and Cassie, please interrupt if I forget anything, because Cassie also is in our office and does the same thing that I do. Although the Human Rights Commission does focus on more than just housing. So my focus is mainly housing, but we also investigate discrimination in public accommodations, as well as discrimination in state employment. But yeah, so you can file a complaint with the Human Rights Commission. In order to do that, you would either call, email, or go to our website and fill out the information for a complaint online. So if you go to our website, there's a specific form you can fill out for a housing complaint, or you can call or email our intake person, John McKelvey, and share the details with him. So we'll just want to know, what happens, who do you believe discriminated against you, and we'll also, John would ask you about like witnesses, documents, and the other evidence that you have. Just an important reminder that just because you call us, you can call to talk about it and figure out what you want to do. Just because you call, or even if you fill out the form, or start drafting a complaint, if it's always up to you if you want to keep pursuing this. So you can call and find out more information. You're not, you're never stuck with this process if you decide it's not something you want to do. So you can call and do that. If you do that, then John and our executive director will determine if there's an actionable complaint. And if there is, then John will draft a complaint for your review. And after he drafts the complaint, he would present it to you to make sure that it's accurate and it reflects everything that happened, and that so that you're comfortable with it, make sure that it's all true. It would be sent to you, and then you would notarize it. After that step, it would go to the respondent, so who you're alleging discriminated against you, and they would have 14 days to respond to it. In the meantime, an investigator would be assigned to the case. So that would be me, Cassie, or we have one other investigator. And so they would, whoever it is, would start researching the case and looking at it, reach out to you, and then after get a response from the respondent. We are required by statute to see if there's any way to resolve it. So we would initially talk to both parties and see if there's, what the complainant is looking for, and if there's any relief that they're seeking, and then talk to the respondent and see if there is. If there's not, then that's fine too. And we go on and investigate the case. And our investigations, we interview all relevant witnesses, we look at all relevant documents, we investigate the case until we think we've gathered all the information we need. If we haven't been able to resolve the complaints, the parties aren't interested in settling, we then draft what is called an investigative report, where we make a recommendation of whether we believe that there's reasonable grounds to believe that discrimination occurred or did not occur. That goes up to our executive director, who then approves or our report, our recommendation, or doesn't, and then we revise it. But once we agree, then we have a 5-member board of commissioners who ultimately makes the decision. So we have a hearing, and parties first can get the report before the hearing, and they can respond to the report if they like, but they don't have to. And then there's a hearing, and they can come to the hearing and mostly just respond to the report. They can't provide any new evidence at that point. So they can come and talk to the commissioners. After that, the commissioners vote if they believe that there's reasonable grounds that discrimination occurred or not. Once they make that decision, the investigators let the parties know. If they find that they believe reasonable grounds that discrimination has occurred, then it will go back to our executive director to try and resolve, to see if she can conciliate and resolve the complaints. If not, in many housing cases, we will then go to court, not all of them, but if no reasonable grounds are found, then that's it for the HRC, but the complainant can still take it to court if they should like to do so. Cassie, did I leave anything out?
I think you covered it. So we do have another audience question, so I will share that with you all. So what if a Section 8 office notices a pattern? What can they do to advocate?
that might be a good testing question. From how I see it, maybe I'm.
Yeah, I think it depends on what you mean by noticing a pattern. So if it's suspicious but not clearly discriminatory, certainly you could call us. You don't have to just be a client to call legal aid. Caseworkers and Section 8 case managers, designated mental health agency people, folks who work at Capstone or community, community actions. It's fine if anybody in this housing community is suspicious about a landlord discriminating and would like an investigation. We can't open it for you as a case. But if you let me know that it's happening, it's very possible that I could investigate it. I can't promise that, but we certainly could investigate. If we hear about things going on in the community, we do want to look into them because so legal aid does complaint-based testing. So somebody thinks, oh, this is happening to me. Can you look into my particular case? But we also do what's called systemic testing or audit testing, where we just look around to see what's happening in the housing market all over Vermont. So we're not only doing complaint-based tests. So we don't have to have a complainant to do a test. It's a little more complicated if we don't have a complainant and we want to bring a case, but that's a completely different situation. I do want to also, while I'm talking, just piggyback off of what Melissa was saying about the complaint process and what you can do if you find that you're being discriminated against. Legal aid does file cases in the HRC and in HUD and in state and federal court. So we do represent people in those cases and all of the fora that exist. We also, oftentimes when we're too full on cases and we don't have capacity to take more, we do send a lot of people to the HRC. And one reason that we like to do that is we like to tell people that the Human Rights Commission is a really great forum to navigate if you don't have an attorney. It's very friendly to people who don't have legal counsel. So if you are in a position where legal aid can't take your case and you're not able to find a private attorney, that the Human Rights Commission is a really great venue for that because it is the most friendly forum for people who can't afford an attorney.
Thank
And
you.
I wanted to add one more thing to the question as well. From the HRC perspective, it's definitely worth a conversation anytime you see a pattern like that or have a concern. You're more than welcome to bring it up with our intake or with us directly, and we can try to figure out where to route that or what can be done about it. The Human Rights Commission, we've been talking about individual cases and the investigations that we do, but the Human Rights Commission is also tasked with public policy work and trying to improve, the equality and the reducing discrimination throughout the state of Vermont. So we can also, even if it happens that the details don't work to bring a specific case or something like that, that can help inform our public policy work. And we can work on the issue one way or another.
Definitely.
I wonder if I can just add one other thing, which is to say that we know in Vermont that so much discrimination is happening all the time, and that sometimes there's a really big gap between what you sort of know and feel is happening and the evidence that we're able to gather to prove that it's happening. So I just want to take a minute to say that just because we didn't find the evidence, or just because we can't win in court or at the Human Rights Commission, doesn't mean that it didn't happen to you, and it doesn't invalidate your experience. I think, there's the justice system has limits, right? And we have big limits on the kinds of evidence we can collect and produce. And so that is a really big barrier to finding justice when you've been discriminated against. So I just wanted to make sure that that's clear to our participants, that whether or not we find the evidence, we honor and respect the experience that you are bringing with you when you talk to us about these things.
And we have another question. When looking for housing, would it be best to mention Section 8 at the last possible moment?
Yes. Yes, with any of these things, always get as far into the process as you can before there's a reason that a landlord might discriminate against you. Sometimes it's harder to do that than others. Sometimes you have no control over that, but where you have the control, disclose at the last possible minute. Don't lie. If a landlord asks you directly, you should tell the truth, because if you lie, you're not going to get the place. And that's a good reason for them to not give you a place. But certainly withholding that information is going to help, and also helps us understand what's happening if we're investigating and trying to gather evidence.
And they shouldn't be asking you that right off the bat. They should be asking you if, if you have sufficient income to afford the place, but not specifically, how or where that income is coming from. So yes, I agree, Devon.
All right, I don't see any more questions at this time, but if anybody else has a question, feel free to add that in the chat.
Yeah, and I would just encourage people, I think, as all of us have been saying, just to call at times if you're not sure, because we can help guide you, let you know if there is the claim or not. But I think, especially with voucher discrimination, it's tough, and we understand that, because oftentimes you're looking for housing and you have a short time to do it. And so even if you might be like, was that discriminatory? It's tough. We get that it's tough to find the time, but we try and make the process as easy as possible. And just, Devon pointed out, and I think it's important, that while you're welcome to have a lawyer, if you should want one at the HRC, you're in no way required to have one. So it's completely up to you.
So I do see one more, it's a comment, not exactly a question, but I will read that to our moderators and see if you want to respond to that. So the audience comment is it, oh, great, it is phrased that way. My mistake. Is it legal to have to pay above what Section 8 says? During the pandemic, my rent was raised and I wasn't working. I was told that I had to pay or move.
I'm not sure if I am totally understanding the facts.
And if that audience member wants to maybe elaborate and type any more detail about what happened, and you can also always reach out to us individually and reach out to our intake if that might be easier. So I can let you know if more pops up. In the meantime, do you want to provide the contact information?
Sure. And then I also wanted to see, Sean, did you have anything else that you wanted to add that we didn't cover?
I think Sean left. He had to go.
Oh, okay. Sorry, I can't see everyone.
I think the question that is being asked in the chat is maybe looking for some specific individual legal advice and maybe should be answered offline. And I think probably there's a little more information that is needed to answer it. Not trying to ignore it, just that we tend to not give individual legal advice in forums.
And you can definitely reach out to
Yeah.
these numbers or these websites and get in touch. But we do have one more question that I think is more general. What kind of policy changes should we advocate for so that Section 8 holders have more housing opportunity and choice in Vermont?
Melissa, do you want to?
I mean, I think it does start with Vermont doing more to create affordable housing. And I mean, I think that is something that a lot of groups are looking to find creative solutions, because, you know, especially right now, we are just, I mean, if you look, I mean, there's such a shortage of housing, and the housing that is available, the cost of it is just skyrocketed. I mean, it's just impossible. But I know there's, you know, some creative solutions of, you know, trying to repurpose some of the buildings, housing stock that we have now into new forms. But I think that's where we have to start. Is, I mean, it's like it's just not there, the housing.
I mean, I agree. I think we do need bricks and mortar, but I also think that there are like common sense policies that the state and municipalities could be taking. So Burlington has had an inclusionary zoning policy on its books for a lot of years. It went through, I'm actually not sure if the revisions were finalized or not, but there was a lot of talk about it about 2 years ago. But what inclusionary zoning is that it means anytime there are new apartment buildings being built, there has to be a certain percentage of them set aside for low income Vermonters. And they usually target the income above what you would typically think of as the income of somebody who is on a Section 8 voucher. But the rents are controlled. The rents are permanently below market. And that makes it possible for Section 8 voucher holders to take their voucher into these brand new apartments and be able to afford them and live in them. And Burlington has seen some success with that. Certainly their policy could be improved upon in a lot of ways. I think we need more apartments set aside. We need to make sure that they're mixed into the buildings, that they're not segregated. So there's like a poor person building and a rich person building, right? People should be living together, and mixed income, mixed use properties. But I think policies like that are important for the health and vibrancy of our communities, and also go a long way towards desegregation, which is something we haven't really talked about, how affordable housing tends to be segregated. It even is in Vermont, and particularly in Burlington. But if we have more, particularly since we're so obsessed with building right now and we're doing so much building right now, all of the building that's happening needs to be, if it's not particularly for affordable housing, if it's market rate housing, it all needs to have affordable housing units within that are fully accessible also, by the way. Get off my soapbox.
Yeah, I think, you know, sometimes education is a very small thing in comparison to some of the other policy changes that might be appropriate. I know I've had a case where a landlord was held accountable for Section 8 discrimination. And that particular landlord just had no idea that that was a law, that was, you know, something that he wasn't allowed to do. So I do also think, while there are some existing platforms and opportunities for landlords to learn that information, that also just making that more widespread is helpful too.
Yeah, definitely. Yeah, there are still quite a few people that will say that they did not know that they had to accept vouchers, and you'll have that direct evidence come in and just say, I don't accept them. That's how I am. I don't think it's worth my while, and and then you have to tell them, like, that's not a choice. So yes, I agree with Cassie. Education is key.
This is my personal opinion and not that of,
I know what you're gonna say.
but I do think it also matters when tenants are organized, and that when tenants have power and when they exercise that power. Vermont is very imbalanced. Landlords have a lot of say. There are a lot of landlords in the legislature and in city councils and select boards all across the state. And, tenants need to have more of a voice in that process. And so one way that happens is not through, filing a case. It happens through organizing and talking to your neighbors and getting together with people. So that's just as important as what we do.
And there's an audience comment too about the proposed rental safety bill that it would include a statewide rental registry. And so that could be a way, an opportunity for more landlords to have access to things like education. And that's all I see for now on our chat.
Great. I think all of us would encourage any follow-up questions if you think of anything after this, but we really appreciate you coming, and yeah, please stay in touch. I think this is an important topic, and I hope that we'll continue to have more discussions around it.
Thanks, everybody.
Thank you.